Hello, and welcome to From the Front Row, a program of the Southern Environmental Law Center. The following is from a presentation to our board by Deborah Murray, the lead attorney in our recent victory overturning approval of the King William Reservoir.
In 1994, we got involved in what has turned out to be a 15-year battle so far, opposing Newport News' proposed construction of a regional reservoir in King William County, Virginia. And let me just take a moment to orient you. As you can see, Newport News is down in the bottom there. There's Richmond. And what Newport News proposes is to create an impoundment on a tributary to the Pamunkey River and then withdraw substantial amounts of water from the Mattaponi River that would then be used to fill the reservoir. And the Mattaponi and the Pamunkey River, as you see, join to form the York River, and that's ultimately a tributary to the Chesapeake Bay. Kay Slaughter and I went down there and we investigated and talked to some groups, and I remember very vividly saying to each other on the drive back, we have to take on this project. This project is a terrible idea, and let me tell you why. First, the environmental impacts would be devastating. The project would result in the single largest authorized loss of wetlands in the entire mid-Atlantic region since the history of the Clean Water Act in 1972. It would also flood over 20 miles of streams. The marshes and rivers of the Mattaponi and the Pamunkey are beautiful and special. They provide valuable habitat for numerous and diverse species, and I can also personally attest that they are a paddler's paradise. The Mattaponi River itself is one of the most pristine rivers on the East Coast, and withdrawals from the Mattaponi River to fill the reservoir would alter salinity patterns and would also harm shad, a species that in Virginia is very vulnerable and has been in decline. Second, the project would do irreparable damage to the Mattaponi and Pamunkey Indian tribes. Now, these tribes are descendants of Powhatan, the father of Pocahontas, and they also have Indian reservations on their namesake rivers. The project would flood important cultural and archaeological sites dating back more than 1,000 years, and it would have put at risk their traditional fishing grounds. Third, the project is completely unnecessary. Studies commissioned by our allies and then later confirmed by the federal government's own independent studies showed that Newport News greatly inflated its demand projections in an attempt to justify this project. And the studies also showed that there are far less destructive alternatives available to meet Newport News and the region's future water needs. Building the reservoir would take us down the path simply of unfettered growth in our coastal regions without regard to cost or consequence. This project has been a real roller coaster ride. As I mentioned, we got involved initially in 1994 in federal permit processing, and our legal battles began first in state courts challenging the state permits required for this project, and then proceeded to federal court over the federal permit. The first of the state permits was issued in 1997, and we filed suit in 1998. I'm just going to give you the highlights. It took us 3 years and a favorable decision from the Virginia Supreme Court simply to establish the legal right to bring the lawsuit on behalf of concerned citizens. And we've had other significant victories along the way in this case, which have only been followed by heartbreaking political reversals. In 2003, another state agency denied the second permit on the basis of the unacceptable impacts to the Mattaponi River and the shad fishery. But it reversed itself only a year later, and that leads me to the federal permit. I have to put this a little bit in context. It is rare for the U.S. Army Corps of Engineers to ever deny a permit. But in this case, the Norfolk District of the Corps, which had the permit under review, listened to us and our allies. And after an extraordinarily exhaustive and rigorous scrutiny, the Norfolk District agreed with us, recommended that the permit be denied, agreeing that the reservoir is unnecessary, that there are alternatives available, and that the devastating impacts on the environment and the Native Americans were unacceptable. The Norfolk District concluded that this permit is not in the public interest. We were overjoyed at that, and this amazing decision happened to coincide with the annual powwow that's held on the Mattaponi Indian Reservation. And Kay Slaughter and I went to that, and it was just an extremely moving experience to be there. But Governor Gilmore, then the governor of Virginia, he objected to the Norfolk District's recommendation, which had the effect of taking the matter out of the Norfolk District's hands and elevating it, sending it up the chain of command to the North Atlantic Division of the Corps in New York for a final decision. And after a very cursory evaluation, the North Atlantic Division overturned the Norfolk District and ultimately in 2005 issued the permit. We filed suit in federal court in July of 2006, and on the 31st of March of this year, the U.S. District Court for the District of Columbia invalidated the permit and agreed with what we and the Norfolk District of the Corps had been saying all along regarding the lack of need for the reservoir, the availability of alternatives, and the harm to the environment. I have to say that in the 21 plus years that I've been at SCLC, this case is really the closest to my heart. I'm very happy to be able to share this victory with you today. It's not over yet, but with your continued support, we will stay the course